Do things go wrong in oil trading?
Yes.
Oh, never. When do they tend to go wrong? Once we start putting stuff on ships, or as we arrange a loading, delays, problems with the vessel, whatever it might be. So once we get shipping involved or transporting involved, that's when things tend to go wrong. Swaps, futures, those sorts of things, it's pretty rare to have an issue where things go wrong. But in physical oil trading, it's fairly common. If it's a small issue, no big deal. We can settle it amicably, sit down over a cup of coffee or a beer and hash it out. But if we can't reach an agreement, if it's a lot of money or, the traders or the company gets, oh, this isn't our fault, we're not going to pay for this. And you never know. You call up your lawyer, you speak to your in-house counsel. And explain the problem. They go, oh, I don't really know. Call up our, external law firm. You call up the external lawyer, Allen and Gledhill, HFD, Auden, whoever it might be, and you present the problem to them. And you're sure you're right. Yeah, I sold this guy a cargo, but then he came to the office and shot 4 people in the office, stole all our computers, and stole the cargo, and he left a note and a video showing that he did it. Do we have a case? What's the lawyer going to say? Well, I don't really know. It's not sure. All the time. And it's not because they just want to drag it out. Well, you need to give me a month to think about it and run up some invoicing bills and stuff. It's because sometimes you go to court and you're really amazed by the decision. You think you're absolutely right. And the judge sends out a decision saying, well, based on a case from 1832, I find for the other side. What? 1832? What are you talking about? Yeah, some wooden sailing ship sets a precedent for these kinds of cases. Anyway, so we might end up in court, we might end up in arbitration. Where should you do it? Where should you go to court? Where should you go to arbitration? Well, what language is your contract probably written in? It's written in English, so where should you go to arbitration or court? Someplace where they speak English, which is going to be here, the US, Singapore. I'm not sure where else you might want to end up, maybe in India, but I'm not even sure about that. But generally people will pick London or Singapore. It's basically the same system. All the lawyers in London went to law school at Oxford or whatever anyway, so they're all English trained. If your contract's written in English, do you have to use English law? No, you can use any law you want, French law, Ugandan law, whatever. But is there a preference for a law? English law. Why? Do you know why? The goal of English law is to have business continue and to compensate. It's not to find fault. It's to have liquidated damage, compensation, paying people back for things that they suffered. So when you go to court in England, they're simply looking for a solution to the case. How much did it cost you? Okay, it was his responsibility. He's going to pay you this much. Other places, they don't have the same flexibility. French, some people choose French law. Contracts are written in French or not. But the problem with French law is it's not as flexible. In an extreme example, a French judge will be looking through the books going, let's see, no, there's absolutely no law that talks about an oil tanker being late by 30 days in this port, so I don't know what to say. While in England, they can adapt and interpret much more freely. You can use English law and have a court case in Singapore. You can use English law and have a court case in London. Or what's the alternative to court?
What about U.S. law?
U.S. law, there's sort of a U.S. law. If you have a court case in the U.S., it's a state court. I guess if you appeal it, ultimately you get to the Supreme Court, but I'm not sure how far commercial cases would go in that sense. So you would probably pick something like New York. The problem with New York law is you can end up in a court case where you're going to be punished, you're going to be fined. So they'll say, well, you owe him $100 million in damages, that's what we assess the real damages, and you were very naughty, so another $200,000 for his pain and suffering. New York law is also, it's far easier to get a judge to do something. So you're in you have a contract in New York law, somebody owes you money, you go to a court, you file something in a court in New York, and the judge issues a writ, and you can seize the guy's vessels all over the world. So the company has 50 ships, and everywhere in the world there's someone in the Port Authority who seizes their vessel. As soon as the ship owner finds out that his vessels have been seized, he sends his lawyer to New York, find a different judge, and the judge issues a different writ releasing all the ships. And sometimes this lasts like an hour or 2 hours where the ship's been seized and then it's been freed. So that creates some problems. The English don't like that. The English don't like the idea that you're being petty, you're seizing people's ships and creating additional costs. One of the rules in English law is that you have to mitigate the costs. So if, for example, a trader comes to load a cargo in your refinery and he does something that creates a fire, something the ship does, whatever, creates a fire in the refinery. You can't just start yelling at the ship and yelling at the trader, oh, my refinery's on fire, and not do anything about it. You have to try and put out the fire. And if you don't try and put out the fire, put it out, the judge will say, what'd you do? Well, I didn't start it. I didn't start the fire. It was his fault. Yeah, but you didn't try and put it out either. So if you don't try and mitigate your losses, you're going to be in trouble in English court. You sold a cargo to someone and he flakes. You know what flaking means?
Did not show up.
They just turn down the deal, they run away, whatever. Oh, I don't want the cargo, I don't want the deal anymore. And instead of trying to resell the cargo, you just leave it floating around, you don't hedge it, you don't protect it, you let it, it's a cargo of gasoline, you leave it on the vessel for 6 months, it deteriorates, whatever it might be. The judge will say, what are you doing? You can't do that. Well, it's not my problem. He didn't say anything. The judge said, yeah, you had a responsibility to limit losses, to mitigate losses. And it could be that even though it's the other guy's fault completely, the judge will say, no, sorry, you didn't mitigate losses. Case dismissed, it's all your problem. So you have to be careful about that. So this notion under English law is that we're trying to make business happen. We're all gentlemen or gentlewomen playing in the world of trading. We just want things to continue. The end of the case, shake hands, and off you go and do another deal sort of thing. The alternative to court is what? Arbitration. Which one's better? I've done arbitration, I've done courts. It's not as cheap as it used to be. Arbitration's become expensive. It is much less formal, and it gives you a couple of advantages. I've gone to arbitration like this, right? Just next door, just sit down like this and chat away. So it's very informal. In court, they made me wear a tie and a jacket, and you stand up, and every time the judge stands up, you stand up and bow and whatever. So they don't wear the robes and the wigs anymore. In Singapore, they wear the robes in court. So when you go to court, you get assigned a judge, and you don't know who it's going to be. They just have a rotation. If you have a judge who knows about oil trading, you're lucky. But there's no guarantee. You could have a judge who's never heard of oil trading. He's done lots of cases, and they, educated, and they study these things, but he's never done an oil trading case. I've had judges where, he had a vague idea about oil trading itself, the physical aspects of shipping. They're very good in shipping usually, but not so good in the trading side. But a big part of the case hinged on hedging. So I wrote a couple of papers for the judge, trying to keep it really simple and developing a little bit more. And then in court, I was explaining to him, because he asked me, how does hedging work? So I spoke to him like you teach a 6-year-old for about 15 minutes. I could just see his eyes glazing over. And at the end of 15 minutes, what I thought was the most brilliant explanation of hedging in the history of English law, he just looked at me and said, well, right, let's... I'll see if I can consider that. Right, moving on. And not mentioned all his decision was not a part of the case. He just didn't understand it. When you go to arbitration, there's usually a panel of 3 arbitrators. You appoint one, the other side appoints one, and those 2 will appoint the chief arbitrator or the president of the panel, whatever you want to call it. Now, if you appoint an arbitrator, logically you would appoint someone who understands oil trading. And the other side, you would expect them to do the same, and therefore those 2 should choose someone to preside over the panel who also understands oil trading. So there's an advantage in that sense. Otherwise, they're both enforceable. The courts have, it's a state entity. They have an enforceability. If you don't respect the decision, they'll send, the bailiffs or seize your accounts or whatever. Arbitration has the same power. So just because it's just arbitration, I don't have to obey. You do. They have the same enforcement power as a court has.